Hello, everyone, and today we are going to ask the question, what makes you a successful at securing multi-million-dollar verdicts and settlements in personal injury cases? And that's specifically towards Mitch. Welcome to another informative segment of Live with Mitch from the law firm of Proner and Proner. I'm your host, Mel McGoyop, and we sit down with the expert himself, Mr. Mitch Proner, a personal injury attorney with over 30 years of experience, here to answer your questions or any interesting topics that you might find useful in the personal injury world. How are you doing, Mitch?
Doing well. Excited to present some information again, and hopefully the viewers and listeners find it entertaining and informative.
Definitely. Now, before we start, just remember, folks, if you need to contact us, all consultations are free and confidential. Call us at any time at 1-800-321-1234. All right, so let's just jump into it. So yeah, I mean, how do you approach complex cases such as construction accidents with multiple liable parties?
Well, so a construction accident case or any case with multiple defendants is challenging. First of all, in a construction case, you might have the owner, the GC, subcontractors, site safety inspectors, different people that are all going to be trying to protect each other or play ignorant and, for whatever reason, distance themselves from the incident. You have insurance companies that disclaim. They say they're not responsible for this incident. So there's coverage issues that you often have to deal with. There's contractors that say, we weren't even working there then. This guy's not even our employee. We don't even know what he was doing. This has nothing to do with us. And it's like an onion or a spool of thread where you have to keep unwinding until you get to the heart of it. And there, usually, if you know what you're going after, you find the case, and it becomes difficult for them to get out of it. And then either they settle it, or you can go to trial and you'll be successful. And fortunately, I've been successful in trying construction accident cases and settling them for multi-million-dollar results. On the other hand, I've had cases where I've told my client, I can't represent you any longer because you aren't honest with me.
Yeah.
And I figured that out too. and you know, I'm not looking to waste my time trying to prove a case that's fraudulent. It's not worth my time. But if somebody is deserving and they really did sustain injuries, and the injuries were in a construction or demolition project, I can usually find somebody that's at fault. Even if they're trying to blame the worker. And oftentimes they do. They say that there was safety equipment there that the worker could have used but failed to.
Yeah.
They say that they had rules and regulations the worker didn't follow. They say the worker wasn't observing for their own safety, and they try to hold the worker responsible. And most of the times, I would say 99.9% of times I found it's not the worker's fault. It's the GC, it's the owner. It's the people that are responsible for maintaining safety at a site that failed to maintain that safety, and blaming the worker is wrong. And so basically, it starts off with, you got to do your work. They don't just fall on your lap. And you got to get your investigators going. And then you have to serve discovery requests. And then when you don't get the discovery, you have to follow up with motion practice. And if you do get this discovery request and it's non-responsive, You have to get the witnesses, get them sworn testimony from them, and get them to commit to their version. And then from there, that's where you catch them. So, I mean, oftentimes they say, oh, we don't have any records. That's all we have. You know, everybody nowadays is using text messaging and emails, and that's not the records they exchange. And I've had to get, and it's nothing new, but I've had to get court orders asking for exchange of the records that I know that are there. And it's doing the homework, and that's where you make the case.
So would you say this is like all the stuff you mentioned is a large portion of what makes you such a successful at securing multi-million-dollar verdicts and settlements in personal injury cases? Anything?
There's more. There's more to it than that.
Yeah, I know. Sure.
So,
a lot more.
First of all, that's number one.
Okay.
Number two, I'm experienced.
Yeah.
I've taken as many as 12 verdicts in a year, which, if you think about how many cases you actually pick a jury and they settle, that's an enormous amount for any attorney.
Yeah.
And if you ever hear like an interview with a comedian, they don't just go on Netflix and present their show and they kill. It doesn't work like that. They start off at local clubs and they start airing out the material, and they go over and over and over, and they see what's working, what's not working. And all these guys like that are famous comedians now, they talk about just working for years and years and years till they figured out what works and what doesn't. So I've got those 10,000 hours where I tried case after case after case. There were times when I was a young guy where I would take a verdict, and immediately after the verdict, I would be starting my next trial. And I would be reading the file at lunch. I would be picking the jury before I even read the file.
Wow.
And I was just going. And started off with little cases. The first case I tried was my client was driving and he hit a double parked car. And the reason why he hit the double parked car was because he was looking for a sign because it was a unfamiliar neighborhood. And he broke his nose because he didn't have a seatbelt on.
Oh my gosh.
And the driver of the car said he had his four-way flashers on, and the reason why he was double parked was because he was jump starting another vehicle. I won that case. That was the first case I tried.
Oh wow.
And I was given the case to try because nobody wanted it. And I said, I'd take a shot at it. And I won the case. I won it by cross-examining the guy who was jump-starting his vehicle. And I just made his story just not sound like he was telling the truth. Like it didn't make any sense. And so the jury felt that he came into court and lied to them, so they found against him. But I'm talking, this is 1988.
Yeah.
I've tried so many cases since then, so many different cases. So that experience, I'm no longer a new lawyer. When I go into court now, everybody knows I know what I'm doing. The judge knows, my adversary knows, the court officers know, the court stenographer knows, and the jury knows. And that doesn't make it easier. That makes it harder, because the jury is thinking, well, he's just a sharp lawyer. And they don't make it easier for me because I know what I'm doing. They make it harder for me. They don't want to be swayed by a lawyer.
So okay, you bring that up. So why is
But I know how to present the facts.
Yeah.
I know how to, when I start off in picking a jury and into my opening, into my direct and cross of the witnesses, and through my summation, I know how to build up credibility. Because at the end of the day, one of the stories I tell jurors oftentimes is a true story. And I tell them that when I first wanted to be a lawyer, my father said to me, Mitchell, I love you. I only want the best for you, but you're really too stupid to be a lawyer. And that's a true story. And I said, no, I'll do it. I'll be okay. And the last trial I did, I was successful on a really difficult case. And one of the jurors came up to me afterwards. They said, I want to tell you something. They said, you're not too stupid to be a lawyer. You were really great.
That's amazing.
But the fact of the matter is, I try to stay humble.
Yeah.
And I don't think of myself as anything other than somebody who's trying to be honest with the jurors.
Yeah.
And communicate that my client is entitled to something, and I ask them please to take care of my client. And that I think that it's not a game, it's not a hustle. And a lawyer told me that. I was in court just the other day, and a lawyer says to me, "You're gonna do well with this case. I know the game." And I don't want to get the old guy, but I was thinking to myself, for you it might be a game. That's why you lose to guys like me, because for me it's not a game. This is and they're depending on me, and I got to look them in the eye and say I did my best for you, and I do on every case, and they know that. They know that. Anybody that's had me as their attorney knows that it's I don't half play. I'm fully involved. It's not life. It's my client's life, and so I think the sincerity and the hard work and the experience makes a difference.
Yeah, I will definitely stand by that. What you're getting here now, when in these videos and podcasts, is what you get in real life. This is not an act. This is Mr. Mitchell Proner, as you see here. So, you mentioned something about being, razor sharp. So, like, you apparently have this reputation as a razor sharp litigator. Now, is that important when negotiating with insurance companies?
It's made it easier for me. It's made it a lot easier. A lot of times now they just say to me, "What do you need?" We don't have to go through this. What do you need? And I tell them. And it seems like the cases that are the tough ones are the ones they make me try. The easy ones settle. And it wasn't always like that.
Yeah.
And it just got easier. So having a reputation and the experience has made it easier for me and easier for my clients, because they don't want a trial. Everybody wants a good settlement. I know that.
Yeah.
And if you don't get a good settlement offer, they're wondering, why aren't they offering to settle this case? This wasn't my fault. Yeah, I got all these surgeries. I don't understand why they don't want to settle the case. The client is subjective. They can't be objective by definition, because they're the subject of their claim. They're the subject of their story. So they can't see their case from a distance.
Yeah.
The jury is objective because they're not the subject of the story. So they can see it from a distance. They're not a subject in the story. So the plaintiff is subjective, and they can't see the case from the other side. Whereas the other side, they could be subjective also, because they're hearing it, they're seeing it from their side.
Yeah.
And they can look at it differently. And they're talking to their lawyers, and their lawyers might buy into their story. and the defendant's subjective, the plaintiff's subjective, the person bringing the claim is subjective, the person defending the claim is subjective, and their lawyers are working for them. And that's the way it is.
Well, I know if I wouldn't want to go up against you, that's for sure. That is definitely for sure. Well, there you have it, folks. You heard it from the expert himself, Mr. Mitch Proner, very much an expert. I will definitely say that. That'll do it for now. And thank you for taking the time to tune in, whether it's in our broadcast or video broadcast or podcast. We really do appreciate you taking this time. And always remember, you can call us 24/7 at 1-800-321-1234, where consultations are free and confidential. Also, if you haven't done it yet, please follow us on Instagram, TikTok, Facebook, and of course, YouTube. Like, share, and please subscribe so you can get the latest updates. Now, before we go, Mitch, do you have anything else you want to add?
Yeah, I'm thinking of it. And the one difference also is, and you know this from just being around me at the office, I genuinely like this. I like this practice. I like everything about it. And that's a rarity.
Yeah.
Most lawyers hate this. Even successful guys, tremendously successful guys and women, they confide, it's a terrible, terrible career. I hate the judges. I hate the clients. I hate the insurance guys. I can't take this anymore. I don't tell them, nobody wants to hear it. Well, I can't. But the truth is, anybody in my office, my wife, she'll tell you in over 30 years, I never complain about work. I like it. I genuinely like that I'm helping people, that it's intellectually stimulating, and every case is different, and finding the way to win them is challenging and gratifying. And I think that might also give me an edge in that I like what I'm doing.
So this isn't work for you. You actually enjoy it. You're one of those people who gets to enjoy it.
I'd say it's work. I mean,
okay.
You got to put this, you got to do the things, even that you don't want to do. But I enjoy it. I enjoy the work.
That's amazing. Well, thanks again, Mitch, for yet another informative session with you. And thank you all for checking us out. I know I learned a lot, and I hope you did too. We'll see you next time, Mitch. Thank you.
Thanks, Mel. Thanks, everybody, for listening. Hope you enjoyed it. Got